We are now on the record, and this is Bell County cause number 301,420. This is a dash E. This is in the 426 Judicial District Court of Bell County, Texas, and this is in the interest of Thompson minor children. Non-custodial party is Mr. Ron Thompson. Custodial party is Brandy Franklin. And this matters before the court on a super modification of child support and motion confirmed arrears. The court will take judicial notice of the court file and note for the record we are currently operating under a further temporary order in this matter. So all parties have been properly noticed and served. This is at least the second temporary order, so we've gone through this for a while. But anyway, the court will know for the record that both parties are present today, that the ad litem is present, and the state is present. So at this time, the state's the one that brought the pleading. So at this time, I'll go ahead and ask the state for an opening to tell the court what the state's requesting we do here today, what you understand agreements and contests to be at this point. Then I'm going to let the ad litem make an opening statement to tell the court what she's requesting in behalf of her clients at this time. Mr. Thompson and Ms. Franklin, again, y'all probably heard this speech several times before, but I don't let non-lawyers make opening statements. I just want to find out what the matters before the court are going to be and whether or not we have agreements on those and not take oral arguments. Pro se litigants they don't get it right. They always want to make closing statements instead of opening statements. So, but at the end of the hearing, if either of you want to make a closing statement or a closing argument, you're allowed to do so. You're both pro se litigants representing yourself. So you will have that opportunity. But for right now, I just want the lawyers to tell me what we're looking at. Thank you.
Yes, Your Honor. The state is asking for final order today. In the further temporary orders, let me go back a second. I'll let Ms. Cusack confirm, but I believe that the parties are going to continue the conservatorship per the temporary orders. They're going to continue with the app close. I believe that the injunctions should remain as well. Ms. Cusack can tell me if that's different. And then visitation as previously ordered, which looks like it's 100 miles or less apart. And then with the notice requirement, the main issue in this case, Your Honor, is going to be current child support. In the last order, the parties agreed that Mr. Thompson's gross income was $6,000 a month, and support was based on that. However, Mr. Thompson is not in agreement with that. He's asking the child support be reduced. He has provided a 2023 and 2024 tax return that we'll introduce as well, Judge, during the testimony. And then we're going to ask that government health insurance be continued. Currently, it's set at $150. So unless the court modifies, we're going to ask to continue at $150 a month. Current child support is set at $1,300. The state's position is that it should continue at $1,300. And then we need to confirm the arrears. So we'll ask for judgments. The only other issue is that Ms. Franklin is asking that the modification go back to date of service. And that would include the 2 months of April and May of 2024. So Mr. Thompson's not in agreement, but I did tell Mr. Thompson that the state would be asking to set the support for those 2 months at the $1,300, and then just have you add that to the arrearage so we take a more current judgment. But I'll introduce the pay record at that time. And then there's an issue of a non-disclosure. Ms. Franklin is in agreement to provide her phone number and address, her phone number and email, but not her address. But I'll let Ms. Cusack address that issue. Mr. Thompson wants her address included in the order. And then the parties agreed to modify the geographic restriction, which is currently Bell and contiguous, but they've agreed to include Travis County. So it'll be Bell, contiguous, and Travis County.
Okay. All right. Thank you very much, Ms. Cusack.
Thank you, Judge. Basically, this one, although it is a modification, it feels like an establishment. This is one of those cases where there was an order in place previously. There were, I don't know that the parties will both agree to this, but I think the order was finalized with the presumption that the parties were together at the time. So although there was an order in place, there were no specific conservatorship orders, no specific visitation orders, and no child support set. So when you look at the FINA, it's going to show up as a bunch of blanks. That's why, so starting with the back, that's why I think that those 2 months are fair for retroactive support, because there were actually some months prior to that where they were not residing together, and there was not a structured amount of support coming in. So on behalf of the kids, I would ask for those 2 months to be included. Legally speaking, I don't think we can go past that because it was 0 before. So so I do think that those 2 months are fair. As to the amount of support, Ms. Gonzalez-Taylor can provide the math. I'm good with whatever the state wants with that, whatever the court wants. I do want it to be feasible, you know. So if it changes, I'm okay as long as it is, you know, taking care of the kids. As far as the conservatorship issues, again, like I said, conservatorship, I think it should be the same as in the further temporary orders. We did, I think it was joint managing with mother primary. As Ms. Gonzalez-Taylor said, geographic restriction to Bell contiguous plus Travis. As far as visitation, I would ask that it's a modified possession order. I would ask that be placed in the final order. It's a lot like a standard possession order, but just with some minor changes. Like instead of basically the summer is 28 days in two-week periods. And so I think that works well for the kids. Same meeting place, which is the HEB at Stan Schleter in Killeen. The same injunctions as Ms. Gonzalez-Taylor pointed out, the same injunctions from the temporary orders, with one addition. The youngest child is still at booster seat weight and age. And so I would ask that anyone who transport that youngest child have an age and weight appropriate booster seat until she's no longer in that. You know, they're like $25-$40. So I would ask that that safety concern be addressed. The parties have used app close, and I believe that that's been working. There probably would be testimony on both sides that, you know, sometimes it's not ideal as far as the communication, but I do think app close provides a good structure. I do think that non-disclosure is in the best interest of the kids. There have been instances in the past of physical altercations. And I do think that since we did this neutral meeting place and non-disclosure, there have not been any. So I think the evidence supports the fact that it's been working. Then I think that's it, Judge.
All right, then, folks, let's start getting some testimony. Let's start trying to figure this one out. And again, either party wishes to make a closing statement or a closing argument, we'll take that at the closing. Again, a lot of this sounds like it's just the math of the situation, Mr. Thompson and Ms. Franklin. So again, that controls. And if somebody wants something different than what the math shows it should be, then the burden of proof, and I know that's legal mumbo jumbo, but that means the burden of proof is on you who are asking for something that is different than the guidelines are required me to look doing. Then you got to show me why I should do that in a legal way. And again, every 99.9% of people who come before me and want a deviation or want something different is not because they want it to be because it's legal. They want it because the first words out of their mouth are I cannot afford that. And this is what the legislature came up with. And it's kind of like the same thing. The perfect example is if you get pulled over for speeding on I-35 and they hit you with an $800 ticket, the judge is not going to let you off because you can't afford that. Okay, it is what the law requires, folks. So again, that's what I'm looking at. But again, both of you will get to tell the court your side of the story through your testimony. And at the end of the hearing, if you want to make a closing argument or statement, you're going to be allowed to do so. So at this time, Mr. Thompson and Ms. Franklin, unmute yourself. And but I do need you to turn on your video for the moment to raise your right hand, ma'am. But after that, both of you can turn off your video if you wish. So at this time, unmute yourselves and raise your right hands, please. You're muted, Mr. Thompson. Mr. Thompson, you're still mute. Your phone's muted. There you go. Do both of you solemnly swear or affirm any testimony you give this court today is the truth, the whole truth, and nothing but the truth will help you?
Yes.
Yes, sir.
All right, you're both officially on the oath. You can turn off your video if you wish. Put your hands down, and I'm gonna let the state call you as a witness. Then the ad litem will have the opportunity to cross-examine. You may call your first witness at this time, Ms. Taylor. Thank you. And you're muted, Ms. Taylor. Sorry, you know that it does that to you. Sorry.
I'm sorry. Stay with call Miss Brandy Franklin.
Yes.
Ms. Franklin, still state your full name for the record.
Brandy Franklin.
All right, thank you.
Miss Franklin, I just want to put the agreements that you're in agreement with what's already been ordered to be finalized today. As far as the rights and duties of a parent, the court, the further temporary orders has you named as joint managing conservators, with you having the right to designate the primary residence of the children, and that's being modified today to Bell and contiguous counties and Travis. Is that your agreement?
Correct.
On the visitation, well, you're in agreement to keep the app close in the order.
Yes.
And then on the visitation, as Ms. Cusack stated, it's kind of a modified schedule. Are you in agreement to finalizing it per the temporary orders?
Yes.
And then there was injunction language in there that certain things that you and Mr. Thompson cannot do. Are you in agreement to including that and finalizing that as well today?
Correct.
And the health insurance for the child, what is the current health insurance?
They have Medicaid.
Are you in agreement to continue the Medicaid? And you're going to continue that?
Yes, ma'am.
And are you in agreement currently, Mr. Thompson's ordered to pay $150 a month. If the court orders that, you're in agreement to continue that amount to the state as well?
Yes.
Now, in the last order, child support was ordered at $1,300 a month. Are you in agreement, or are you asking the court to finalize that and that be the amount that Mr. Thompson would owe?
Yeah, I guess so. Yes, ma'am.
Yeah. Unless the court finds something different. You're in agreement, of course, if the court
Correct.
changes
Yes.
it. Okay.
Yes.
As far as the non-disclosure, are you in agreement to provide your email and phone number in the order?
Yes.
You understand that if you change that, you would be required to update Mr. Thompson in the future. You're agreeable to that?
Yes.
And you're asking for your address not to be included?
Correct.
Pass the witness. With subject to Ms. Cusack asking her regarding the non-disclosure.
All right,
Okay.
thank you very much. Ms. Cusack, you're a witness. You muted, ma'am. Yeah, sorry.
Sorry. I muted myself so I could take a Tums, and then Miss Gonzalez Taylor's like, pass the witness. I'm like, hold on. Okay, so Miss Franklin, as to the child support, Miss Gonzalez Taylor asked you if you're okay with this amount. When we were in conference, what did you say you wanted on child support? Like, what did you want done today?
I just wanted, it to be fair from what the documents that he turned in displayed, and just go from there. I just want to be fair.
Do you also ask, do you think that so your youngest child, is she under a certain weight and age for where you still keep her in a booster seat?
Yeah, she's so little. Mm-hmm.
I'm sorry, say that again?
Yes, she's still in a boost.
Okay.
She's still in a car seat, I guess, actually. A booster seat. It's a booster seat.
So are you asking that anyone who transports the kids have an age and weight appropriate booster seat according to Texas law?
Correct.
Okay. Also on the issue of the arrearage, So the state, when we get to this, I think is going to include the pay chart that we've seen before. Outside of that pay chart, have you received any direct payments from Mr. Thompson since the child support was ordered?
No, I think I did once. I feel like I did once.
Okay. Do you know anything about that payment? Do you know what that one payment was?
It's been a minute, but maybe
What was it about? Was it like an electric bill or something
it was
like
for, I'm sure it was for something before something got turned off. And I think it was probably under $300 or something like that.
Okay. So, if the judge takes a judgment on that, would you be okay with crediting about $300 for that one payment?
Yes.
Okay. Since then, though, and specifically recently, have you been receiving any direct payments?
No.
Okay. As to non-disclosure, so non-disclosure obviously makes it difficult for the other parent to kind of see where things are. So we have to look at this and figure out if it's best for the kids. Since there has been non-disclosure, have things been better than they were before?
Yeah, it's nothing but pick up and drop off, so it's pretty easy. Move on.
Okay, so why, there was an incident where there was an altercation when you guys lived on the same street, correct?
Yes.
Okay, and so he lived a couple doors down from you, right?
Yes.
Okay, so without going into the whole backstory or anything like that, there was a physical altercation, correct?
Correct.
And were you injured in that process?
Yes.
Were there times when people would show up and bring some of those issues to your door?
Um,
Or was
what?
it, I mean, so
No.
do you feel that have there been times when people have come to your house and been physical with you?
No.
Okay.
Not at that house, no.
Okay. Were there times in the past where there were physical altercations between you and Mr. Thompson?
Yes.
Okay. Can you explain one of the ones that maybe that was more concerning for you?
We did have, matter of fact, we did actually have an altercation once before the courts, where he was supposed to, gave me money. And I would always, if I was in an instance where I needed it before something got turned off, I would just ask for it earlier. And he would make me wait. And so before I took my kids, I went down there to ask for it. And we did have an issue then. And that's been sitting in that house, but that's just one instance.
Do you think that, do you feel safer? Sorry, I had a message. Do you feel that things are more peaceful and safer when your address is withheld?
Yes.
Okay. Sometimes some of the violence does not necessarily involve Mr. Thompson, but other people who are associated with Mr. Thompson, correct?
Our issues have only been me and his, and that last instance was with him and, who he's with. So other than that, I haven't had any outside,
Right. No, what I'm saying is that there have been people who were in Mr. Thompson's home where there had been an altercation between you and that person, correct?
Yes.
Okay. Do you feel that if the judge does non-disclosure, that it will keep your home either safer or more peaceful and free from harassment?
Yep.
Okay.
I do.
What are your worries about that?
I don't want the crash outs and the pop-ups and, the embarrassment of, yelling in the middle of the night outside, calling me out my name. I don't want. Yes, I have videos of so much stuff, and I don't want to have to do that no more.
Okay. What time of night was the yelling and stuff?
I believe it was like at 3, 4 after the club type stuff, I guess.
Okay. And was that Mr. Thompson or was that someone associated with Mr. Thompson?
That was Mr. Thompson.
Okay. I pass the witness, Judge.
Anything on redirect, Ms. Taylor?
Yes, Your Honor, just something briefly. Your Honor, at this time, the state would offer State's Exhibit 1, which is a copy of the current pay record. And both
All right.
parties,
Okay, go ahead. I'm sorry.
I shared the pay record with the parties earlier on screen.
All right, then, folks, this is the official pay record in your case. Is there any legal reason that this information should not come before the court? Right now, this shows what has been paid, and the mother did testify to one extra payment, and we're going to allow that is not on here. We'll allow Mr. Thompson to give his side of that. But is there any legal reason what I have here right now that shows that what came through the state disbursement unit as by court order? Is there any reason I should not allow this in evidence at this time? And I'll start with you, Ms. Franklin. Any objection? Okay, Mr. Thompson, you're muted again, sir. Any objection?
No, sir.
All right, state's one's admitted. You may proceed, Ms. Taylor.
Yes, and Ms. Franklin, are you asking that the court start the modification of support back to date of service, which would go back and you'd be able to start at April 1st of 2024? I pass the witness.
All right, anything else on recross, Ms. Kuzak?
No, Your Honor.
All right, I'll let you go ahead and call your next witness then, Ms. Taylor. Thank you.
Yes, state will call Mr. Ron Thompson.
All right, Mr. Thompson, state your full name for the record, sir.
Ron Roy Thompson.
All right, thank you. You may proceed with the witness at this time.
Mr. Thompson, I want to confirm the agreements. In the temporary orders, you and Ms. Franklin were named joint managing conservators, with Ms. Franklin having the exclusive right to designate the primary residence of the children. Are you in agreement with finalizing that portion of the order?
Yes, ma'am.
And then are you in agreement that you're going to change the geographic restriction to Bell and contiguous counties and then also include the Travis County?
Yes, ma'am.
And are you in agreement that y'all are going to continue with app close for communication?
Yes, ma'am.
Are you also in agreement to include the injunctions, which were the certain things that you and Ms. Franklin were prohibited from doing? And just finalizing that portion today as well. And those were, I'll give you an example that both of you are not allowed, prohibits both of you from engaging or allowing other parties to engage in physical altercations in the presence of the child.
Yes, ma'am.
Okay. And then on the visitation, are you in agreement to finalize the visitation per the temporary orders?
Yes, ma'am.
And as far as your information being included in this order, you're in agreement to provide your address, phone number, and email, and your employer. Okay. Now you've heard Ms. Franklin is asking that her address not be included. What is just briefly, are you in agreement or not with that?
I think I should know where my kids are at all time.
Okay.
So no,
And
I'm
then,
not in
okay. And then are you in agreement that currently the children have government health insurance and we're going to continue that in the order?
Yes, unless I could provide insurance for myself.
Do you have health insurance available currently for the children?
I have for me.
But do you
No, I
have
don't
any
have.
for the children?
No.
You
I'm
understand-
agreeing. That's what I said. Unless I decide to get insurance for them for myself.
Okay, here's the deal, Mr. Thompson. If you decide to do that, sir, you'll still have to come back to the court and get that memorialized in a new court order. Right now, this current court order is going to leave that up to mom, and then you're up to pay it. If you want to change that, you got to come change that through the court system. You understand, sir?
Yes, I know that.
Okay, good enough then, sir. Thank you. You may proceed, Ms. Taylor.
Yes, Your Honor. Mr. Thompson, the last time that you were in court, which was in December of 2024, the order states that your gross income was $6,000. Were you in agreement at that time that that's what it was?
At that time, I was giving Miss Franklin 300 a week. That's how we.
Sir, listen to the question. The question was, are you in agreement that at that time when you gave that information, that was the correct amount? The $6,000 that you were earning, your gross, sir. That was the question.
Yeah. Yes.
All right, thank you.
Now, Mr. Thompson, are you asking the court to reduce your current child support going forward?
Yes, ma'am.
And what is it that you do for a living?
Contract work.
You do contract work. Do you have a business?
Yes, ma'am.
What is the name of your business?
Thompson Construction.
R. Thompson Construction?
Yes.
And how long have you been in that business?
Since 2014.
And do you currently have any employees?
I got one at the moment.
Did you have employees in 2024?
Yes.
And what is it that you're currently earning monthly in 2025 from this business?
Well, I can't give no numbers. I know it's just been slow. It's been
Okay.
real slow. I get a job here, might be home for 2 weeks to a month.
How much
Gotta
do you
catch
pay?
up.
How much do you pay your employees?
I just got one right now, and I give him 15 an hour.
You work him 40-hour weeks?
No,
How many hours is the employee getting?
I can't say right now. Like I say, it's just been slow. So
Right.
like this
Now,
week we probably work. We're working today, tomorrow. We probably work like 3 days out the week.
do you have any idea how much you've been earning or taking home for yourself since January of 2025?
Maybe about 2,000, 2,500.
Are you
Maybe a little 2,500.
and the order says that you have 3 kids before the court, and then you have one other child that you're paying support for. Is that correct?
Yes, but I just be present for the other one. I haven't been paid nothing, but
For
I
the other
haven't-
child?
yeah, but I do. Me and her mom have an understanding, but I do take care of her.
Yeah, how old is that other child?
She's about to make a year.
1 year old?
Yeah.
All right, let me go back to your income. So you're taking home about 2,500, you believe, monthly?
Yes.
Now, you did provide some tax returns, is that right?
Yes.
And you provided 2023 and 2024?
Yes, ma'am.
And without pulling the documents up, do you remember how much your business made in 2024 before the deductions?
I think he told me it's 108.
108,000?
Mhm.
And then after the deductions, do you know what you're claiming to have been your income from last year?
I think it was 15,000.
15,000. So if we divide the 15,000, it comes up to like a little bit above minimum wage. Is that what you're telling the court that you made last year?
Yes, that's what in my taxes.
Your Honor, just because I know the court's going to want this information, Mr. Thompson did, I did forward what I guess would be considered Mr. Thompson state's respondent dad's Exhibit 1, which would be the 2024 tax return.
All right, Mr. Thompson, I've got right here well, I got a couple here. Let's see. This is 2023. Let me bring up 2024. That's the most pertinent one. All right, sir, this is your tax. This is the filing copy of your tax returns for 2024. The state wants to bring them into evidence. If I do bring them into evidence, sir, don't worry, they will be sealed and no one and the court records in a separate envelope with a sealing tape on it, so no one can get to it without and getting the court's permission to unseal it. So is there any legal reason, sir, this should not come into evidence at this time?
No, it's no problem. I should.
All right, then this is respondent fathers 1, and it is admitted. Thank you.
And
I'm sorry, Ms. Kuzak. Any objection, ma'am? Okay.
I'm good, Judge.
I
Thank
knew
you.
there wouldn't be, but I'm sorry. I gotta ask. Thank you.
I got you. I got you.
Your Honor, may I share my screen to show some of what was in that his exhibit?
So long as it's been redacted, because we are on YouTube. Okay. We are okay. Is there if it's not redacted, then I'll go ahead and I'm going to stop the YouTube feed or pause the YouTube feed for now, because again, this is personal information that should not get out over the way. So
Okay, so you're stopping YouTube for a second?
yeah, I'm gonna stop. I'll restart when we're not
Okay.
done.